All right, are the parties really on Malik?
No.
Yes.
Yes, Judge, I'm present.
All right, who's the prosecutor?
Again, Mr. Garahan's my selection.
All right, and so that the record can be clear, the court is aware of who can and cannot appear by Zoom and who the court gave permission to appear by Zoom and not by Zoom. So there's no need to come in hot with, you told her she could appear by Zoom. I already know that it's on the docket sheet. The Zoom link changes and it changes every single month. The clerks in the back do not have the Zoom link. Once they come out here, that's when they're given the Zoom link. So where are we on discovery?
Well, Judge, may I respond? Because I think
No.
that it is, well,
Where are we on
I
discovery?
think that is.
Where are we on
I
discovery?
I think, Judge, I feel like you don't want to hear the response, but it's important because this happens to people. What happened was I came yesterday, I wanted to get the Zoom link. I actually checked.
I don't give the Zoom
they
link
checked-
the day before.
Yeah, they checked the docket.
I don't give the Zoom.
They said there was
It
no.
has Zoom reading right there. You see that on the docket? What does it say? Zoom. You know what that means?
But then the
That
court
means
issued a
that
bond
your client,
forfeiture.
I have not issued a
Well,
bond forfeiture.
on the video.
All right,
it
so
went to
here's
my
the
client.
thing. Where are we on discovery?
Discovery, Judge, it's Northeast Methodist Hospital. It was requested. We've looked, when we went up during lunch, we have not received those records from the hospital. So they're not in our possession at this point.
So when will you have those? Because we've been waiting
It was
for a while.
Sorry to interrupt. They were supposed to be here. I think the subpoenas mentioned September 25th. That's I'm incorrect. I don't know, but they were supposed to be.
You're
here.
correct, because it's on the docket sheet.
Okay, and we don't have them. So they're not in the state's possession at this point. And when we were during the lunch break, I had the discussion with my investigator to hunt those down, and we're probably gonna have to request them again. I just don't know why that they have not responded.
All right, so what I have is the outstanding medical discovery, and it's your client's discovery. Miss Malik, if you can start your video, please.
She's been trying to juggle a bunch of stuff. She's been on and off since she got the Zoom link, so.
Do you have her, this is your client, correct?
It is.
Okay, could you unmute for me, please? All
Yes,
right.
ma'am.
What I have is outstanding medical records of your client and the state was to upload. Is there different medical records that we're looking for?
Judge, what we're looking for is there was an emergency detention on the
Mhm.
day that my client got taken into custody, so they are trying to get the police / you probably hospital / court document / all of that should be in those medical records. So we're trying to get those.
All right, so do y'all know maybe if, usually those records, if she was taken into custody and then had the emergency detention, sometimes the sheriff's office may have them in their records potentially. And when I say the sheriff's office, I mean their health department, their infirmary. So they may have it.
Right, sometimes university has the beginning ones, and I think that's what we're trying to look for.
I guess, I mean, they're actually, I mean, I was unaware of I mean, I might have been before the discussions, but I'm not remembering independently. But the only thing that I've seen that we requested is Northeast Methodist Hospital records. But if they took her into custody or emergency detention, there should be a report. So
Yes.
I don't know if that report's in the file or not, but.
The police report's in the file, and I know just you have a million cases and that this one is, I know you know a little of it, but it's in the police report that's what happened, and that's why we're trying to get that.
So do y'all think they may have it at the sheriff's?
It could. I mean, if it says in the police report, emergency detention judge, that might be what they used. And then any type of document, like the page, whatever that they fill out when they take her to the hospital, it would be at the hospital. And I don't know if they retained that or not, but as far, I mean, I don't.
USB to Mr. Edelman to do that. So,
Okay, that's CPS.
yeah.
All right,
yeah.
and what I can tell you too, if that's the when you say CPS, you mean Child Protective Services? All right, has anybody looked at that? Because sometimes if there's an emergency detention, they will have it in the CPS records as well.
They have a USB. I don't have the full copy of that. They probably, I'm guessing, have part of it. And then we're still gonna need, the rest. But yeah, I mean, I think that that's a good starting point.
All right, so this is what I am going to do.
But we uploaded it.
Is it new?
It says other police report.
Oh, I don't know if it's uploaded. I saw a NOAD and I saw something else that was uploaded in the NOAD.
All right, so we're gonna recall this back on November 21st to see where we're at by discovery.
Okay.
And so if you all can look in once you get the CPS records, look in there and see if it's there. And if somebody can check with the jail to see if they have any documentation.
I'm gone that week, Judge,
Mhm.
and so if I can't, I mean, if you're fine with me appearing by Zoom, I can appear by Zoom, but I'll be out of state. I have a wedding on the 22nd. I think that's a Thursday. I have a wedding on the 2nd. So if you could do it either the week before or the week after
We can bring it up
Thanksgiving.
on the 14th.
Okay, we can try for that. That's perfect.
All right, so we're coming back on the 14th.
And are we still muted? Can we be muted?
Sure, let's, just 1 second.
But I believe we do have the medical records and I believe we do have the CPS records in here.
Oh, well, if you do, that's great.
Just, I mean, and
That's a good
that's,
start.
that's why, because I did mark on here and I checked off that we have the CPS records and the emergency detention or medical records. I believe that because this envelope that I just showed to the court and defense counsel, it was not opened.
Okay,
And
so,
so, and I believe it's patient, so I believe we have both.
all right, so then what we'll do then is,
Well,
state, you'll need to, we're gonna reset this to December 2nd and state you need to be prepared to tender an offer on that day.
That's.
All right.
And I'm gonna look at this, Judge, and I'll let you know, because I think if it doesn't have the court stuff and everything, I will let them know, hey, there may be some other, because I think that if it is an ED, there should have been a court order, and if the medical has it, they have it, but I also kind of want to see the court stuff, so I've asked them to see if they can possibly look into that as well.
All right, we'll come back on December 2nd. State at that time, you need to be prepared to tender our offer.
Oh, I did.
Okay, perfect, thank you.
And hey,
And Miss Malik, where are you at? Are you in Bear County?
Yes, ma'am.
All right, so then since December 2nd date, that's the date that the state is going to tender an offer. You'll need to be in court on that day, okay?
Yes, ma'am.
All right, and that'll be at 9 a.m.
Yes, ma'am.
All right, thank you. You can be
Thank you.
excused now.
whatever.
I think it-
Okay. Yeah, and then you can also, I'm gonna look at this.
Deputy Laura? Where is, Anthony Cantrell's client? All right, thank you. All right, who's here on Otillo Espinoza Ruiz? All right, Yahir Romo? Norma, does somebody want to grab Anthony Cantrell in the hallway? Because they just brought his client out. Yeah, I think he went in the back hallway or something. Court is calling 2024 CR 3657, State of Texas versus Yahir Romo. Can I have parties announced for the record for the state?
Andrew Harris, Adler.
Defense,
Renee Munoz.
are you Miss Romo? You need to speak up.
Yes, ma'am.
Counsel, have you received all of the discovery?
Yes, Your Honor.
Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Romo, did you review application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, waiving count one, proceeding on count two.
No objection, Judge.
All right, Ms. Romo, and Norma, if you'll call Mr. Cantrell. All right, Ms. Romo, did you review the document entitled Court Admonishments with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand in count two, you're charged with manufacturing, delivering a controlled substance, penalty group 1 gram to 4 grams? That's a second degree felony.
Yes.
I'm sorry.
Yes, ma'am.
Shouldn't this be a second degree? If y'all are doing it as a manufacturer.
Actually, knowingly possess.
Oh, you all have it listed as the offense as manufacturing and delivery.
That is my mistake, Your Honor. You'll allow
Sorry
me
about
to
that.
correct it.
Sure, no problem. All right, so count two, they are proceeding on it as just a possession. You
Yeah.
understand?
Yes.
So then that's a third degree felony, and they're just changing the paperwork to notate it as possession and not manufacturing and delivery.
Okay.
So the range of punishment for that offense is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
In my opinion, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Ms. Romo, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $1,000 fine to be probated. The state is proceeding on count two only, and they're recommending deferred adjudication. Did you understand that to be the plea?
Yeah.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes, ma'am.
Counselor, are there any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 10 years. There be a TAP evaluation, 120 hours of community service restitution, and a drug court evaluation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged in count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea?
Contained in exhibit 1 in attachments, Your Honor.
No objection from the defense.
State you may be excused.
Thank you, Your Honor.
Did you review the waiver and consent to stipulations with your attorney?
Yes,
Did you understand it and sign it in all the appropriate places?
yes, ma'am.
Again, did you understand you have a right to jury trial? A right
Yes.
for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
If we may, Your Honor.
Anything you wish to say on behalf of your client?
Briefly, Judge, my client's currently 21 years of age. She's been on bond for this offense since March. There's been no violation reports filed. She's also had no positive drug tests. She has been tested negative. I asked my client if she explained she used marijuana a few years ago, but nothing recent. I asked if the court asked her to take a drug test today, what would the results be? She maintained they would be negative, Judge. She doesn't use any substances. She's been successful while on bond. She explained to me that at the time of this offense, it was a bonehead move, trying to make a quick buck. She's remorseful for that, Judge. And I think the state offered deferred for that reason in terms of her age, which she accepted. We're asking a 10-year term. This is quite a long time. The court would consider anything less. She has not gotten her GED, Judge. She didn't complete high school, but I highly encouraged of that of her. And we're asking if the court can place that as a condition so she can work towards that and better her life, Your Honor. But with regard to that, she's just asking for a chance from this honorable court. In terms of the substance, she didn't know what the substance was. She thought it was oxycodone, the M30s. She wasn't even know what the other substance came until I explained it to her within the charge, Judge. So we're respectfully asking that we follow the plea bargain agreements, and she's willing to abide by those conditions as stated for the court.
All right, do you have any children?
Done.
All right. Who do you live with?
My mom and my dad.
All right. Any children in the household?
My nephews,
All right, and what are their ages?
ages 6 and 5.
How long have you been living with your parents?
Since I did move out at one point, but I moved back in. So
Are you employed?
no, not right now.
So why are you not employed? And how long have you not been employed?
I'd say a year now. It's kind of hard for me to get a job
Why?
with the charge that I have right now.
Okay,
And they do background checks. So anytime they do a background check, it just pops up. And, but yeah,
all right. And what's with the tattoo?
just a tattoo I decided to get,
Why?
because I wanted to.
And what does it mean?
The one on my face.
Mhm.
It's just a broken heart.
And what do the other tattoos mean?
Mm, nothing really, is just drawings that I like and decided to get also.
All right. This is what the court is going to do. State, did you want to address the issue? Defense is asking for less than 10 years on probation. And how much are you asking for, counsel?
The court could impose perhaps 7 or 8. She understands it's a significant charge, judge, and she's willing to atone, but a decade seems.
So defense is asking for 7 to 8 years on deferred adjudication.
Your Honor,
Yes.
there's no objection from defense counsel. May I provide Ms. Romo's criminal history?
Yes. Any objection?
No objection.
May I approach, Your Honor?
Yes.
Thank you.
And I know y'all are asking for felony drug court, but they're not going to accept her due to the nature of the charge.
Okay, Judge, I'll make it.
All right. Thank you, State. All right. I'm going to set her deferred adjudication at 10 years. If she completes everything early, the court will consider early termination, but no sooner than 5 years.
Yes, Judge.
So there's $1,000 fine that would be probated, 10 years deferred adjudication, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. And when you're drug tested today, what are the results going to be? And mind you, I'm asking you not to punish you today, because if you use, you will not have violated your probation because you were not on probation. I'm trying to see what conditions to give you. So you need to be honest with me. When you're drug tested today, what are the results going to be?
It would be negative.
All right. I'm going to want a drug test. We'll have felony drug court drug test you today. I'm going to ask for 300 hours of community service restitution. You may be excused.
Thank you, Your Honor.
100 hours of those will be waived upon completion of her GED, or either if she completes some sort of trade school. There's to be regular reporting by Zoom or in person, regular random UAs. And also, counsel, if she were to complete college, if she wants to go to college,
Yes, Your Honor.
then the 100 hours will be waived.
Yes, Your Honor.
I'm going to want field visits 1 time per month for 6 months. There's to be no unsupervised contact with minors. So that means that your parents cannot use you as a person to babysit your niece or your nephew. You understand?
Yes, ma'am.
And are they in the home because of CPS?
No, my brother lives there.
Okay, I asked you who all live there and you just said your mom, your father, you, and your niece and your nephew. You didn't say anyone else.
I didn't say that.
No, you did not.
I'm sorry about that.
You left out your brother? Is that
Yeah.
what it is?
So
Okay.
anyone else other than your brother?
No.
And where are the mother of the niece and the nephew?
She doesn't live there. They're not together.
Okay. So I'm telling you right now, if CPS is involved and you're not supposed to be there, they're going to end up removing your niece and your nephew. You understand?
Yes, ma'am.
Probation. Is there anything else? Yes, let's do a TAP evaluation, and that can be out of custody,
Yes, sure.
and follow TAP recommendations. And if TAP is recommending inpatient treatment, we'll start first with intensive outpatient treatment. Anything else, probation? Is there anything else you need from the court in order to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. In this court, in order to be successful on probation, communication is key. If you have an issue, let your probation officer know. If you feel as though they're not addressing that issue, you can always come back to court. Do you understand?
Yes, ma'am.
And from here on out, everything that you do, you need to ask yourself, what I'm doing, could this potentially result in me going to prison for 10 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. You understand?
Yes, ma'am.
All right, good luck to you. Probation will go over conditions.
Okay, thank you.
Thank you, Your Honor.
You're welcome.
Judge can I approach?
Yes,
Let's get these judgments signed quick, Judge.
sure.
I think it's the 1244 for today.
There you are.
Thank you, Judge.
You're welcome.
I want that. Know how Got my number.
Yeah. Sorry.
Down there,
Yes.
he called mine when he stepped out in the phone publicly.
Who is your client?
Anthony Harris.
Anthony Harris. Come forward.
Your Honor, Mr. Harris, you asked earlier if the state has made an offer. We now have.
All right, thank you. All right. Norma? This is going to be November 14th for a plea deadline date.
And Judge, I had a motion to withdraw. Motion that I'd like to hear.
All right, do y'all have a motion to withdraw?
It should be, I put it in the.
It's not with me.
I have a copy of it.
All right, court is calling 2024 CR 007-896 State versus Anthony Newton Harris. Can I have parties announced for the record for the state,
Andrew Harris Edelman.
for the defense?
Anthony Cantrell.
All right, are you Mr. Harris?
Yes, ma'am.
All right, your attorney has filed a motion to withdraw. He is saying that you will not cooperate with undersigned counsel in his good defense and refuses to accept legal advice from undersigned counsel. He's your attorney. You can accept the legal advice he's given you or not. All right, you want to give him some legal advice?
Judge, it's unfortunate that he has gotten these charges. He's filed as a habitual. And I explained that the state of Texas is not going to reduce this case to a misdemeanor.
Okay, All right, so here's the thing. I don't want to get in y'all discussions. This is what I'm telling you, Mr. Harris. He's giving you legal advice. With regards to plea offers, in this court, I require that the state tender an offer to the defense. The state's off, we can go off the record. The state's offer is its offer. I've been a defense attorney, I've been a prosecutor. The state will review their file. The state will probably talk to your attorney, they'll negotiate, and then the state will make an offer. Your attorney can't force the state to give you what you think is fair in this case. If you think this case should be dismissed, he can't force them to dismiss it, right? If you think that your offer that they're offering you is not appropriate, he can't force them to give you what you think is a fair offer in this case. That's where we are. You can either accept the state's offer or not. If you decide to accept the state's offer, then the court will see if the plea is an appropriate sentence for you or an appropriate agreement. If you decide to say, I'm not accepting your offer, but I will accept this, that's a counter offer. Your attorney will take that counter offer to the state, and the state can either accept the counter offer or reject it. At the end of the day, if you all don't come to an agreement that the court will accept, this is going to jury trial. If you want to receive legal advice from your attorney, you can. If you don't want to listen to their legal advice, because sometimes people think that they are attorneys too, then that's your decision. If you want to go to trial with an attorney and you not listen to their legal advice, then that's completely up to you. Motion is denied. We're coming back on November 14th. On November 14th, you need to let the court know whether or not you've reached an agreement.
I don't get no say so. I don't get to say nothing.
Oh, do you want to hire an attorney?
It's not that. Prior to this, he told me.
No, here's the thing. I don't want to get into your conversations that you've had with your
This is the
attorney.
legal advice that I got from him.
No. Here's the thing. I don't want to get into conversations that you've had with your attorney because that's attorney-client privilege.
That's crazy.
Yeah, I know. Sometimes it is that way. So what will end up happening is his motion to withdraw is denied. If you want another attorney, you'll have to hire one. So if you want more time to speak to your attorney, you can either speak to him now, or either if you want to be brought over on a different day for your attorney to show up to show you everything in the state's file, the court will make arrangements for that.
He's asking me, what do you want to do?
Do you want to, your attorney is here to speak with you.
I want a different attorney, man. He's not fighting for me, Your Honor.
Let me ask you this. What do you consider fighting for you?
He ain't come up with no plan. Everything he said he gonna do, he ain't did.
Okay, so this is what I want you to do. I want you both to sit in the box and counsel, talk to him. All right, we're coming back on November 14th for plea deadline day. Yes.
I have Daryl at the state with me. Can we talk for just a moment in the back or wherever about scheduling on RC? I just want to
No, just
Okay.
let them pull the file because it should be written in the file.
She's not experiencing it, Judge.
Yeah.
I mean, I don't have any, I'm not even,
Just
doing this anymore for the most
I was
part.
waiting for the camera.
God,
You're enjoying your life.
I'm like, I have so many things I have to do.
She's an ultimate newbie in the one
I
eighty-seven.
know.
Okay, good. Thank you. Thank you.
I'll be back.
All right, who's here on Holcoin? Holcoin? Oging? Ah, you know what? It's just like French. You're not supposed to pronounce the H. All right, court is calling 2024 CR 00778 State versus Christian Oging. Could I have the parties announced for the record for the state?
Andrea Vargas for the state.
Sean Shepherd for defendant, we're ready here.
And are you Mr. Oging?
Yes, ma'am.
Counsel, you received all of the discovery.
I have your honor.
Did you review it with your client?
Yes,
Court will find that the state is in compliance with discovery. Are there any applications in this case?
there should have been, Judge. We defer this.
All right, you may want to pull it just to make sure.
I'll do
that's
another
there.
one just real quick.
Are you Mr. Oging?
Yes, ma'am, I am.
All right, did you apply for deferred adjudication in this case?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
I believe so.
It tells you what you're charged with?
Sorry, Judge, could we have counsel step away?
Excuse me, no talking. We on the record. If you're not talk behind the court reporter, just ask them to move your guy to the other end. Mr. Oging, this is the true bill of indictment. It's a document that tells you what you're charged with. Did you review that with your attorney?
I did not, ma'am.
Counsel, you want to,
I'm sorry.
counsel, you want to show that to him?
Yes, I apologize. We did, but. Yes, we did. I stand corrected, ma'am.
All right, did you understand it?
I did.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Oging, did you review the court admonishments and waivers with your attorney? Did you understand it?
I did, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with assault, choking, strangulation? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I did.
Okay, counsel, you both need to sign that.
I'm sorry. Thank you.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine. Counsel, has your client been able to provide you with any defenses?
Yeah, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Oging, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Absolutely not, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? And did you understand it?
Yes, I did.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the plea?
Yes.
Defense is at the plea.
It is, Your Honor.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, I did, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years, 40 hours of community service restitution, no contact with Desiree Molina, TAP, BIPP, and follow all recommendations. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty Not guilty or no contest?
No contest.
State any evidence.
State offers states exhibit 1 and all attachments.
No objections.
Mr. Oing, did you review, state you may be excused.
Thank you.
And did you speak with the complainant?
Yes, we did.
Thank you. Mr. Oing, did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes, ma'am.
Did you understand it? And
I
did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Off the record, counsel, we're out of trial court certification, so that's just a copy.
I'm gonna give it back.
All right, thank you.
Judge.
After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We're asking to do so, Your Honor.
Anything you wish to say on behalf of your client?
We're just asking the court to follow the recommendation, Your Honor.
All right, do you have any children?
I do have children, ma'am.
What are their ages?
My son Caleb is 11 years old and my daughter is 6 years old.
All right, and the complainant in this case, is she the mother of those children?
No, ma'am.
All right, and how did you meet the complainant?
I met her at a restaurant, ma'am, originally, 2022. And
So what was this argument about?
it was an argument that was totally blown out of proportion, ma'am.
I mean, obviously, because we're here.
Well, I understand that, without getting into the depths of it, ma'am, yes, it was an argument. I'm choosing to take responsibility, although I don't want to take it to trial because I do want to get back out there to my children, be a father, of course, get a job, be a productive member of
When's the
society.
last time you had employment?
It's been quite a while, ma'am.
How long?
I want to say close to 2 years.
2
Yes,
years.
ma'am, it's been over a year.
So that means that if your children have not eaten for 2 years because you had no employment, they would have starved by now. You understand? If you're going to have children, you need to take care of them financially. Do you understand?
Yes, I do.
Has Child Protective Services been in your life?
Never.
And who are the children with?
My son, they're both with their mothers. I'm sorry, my daughter's with her grandmother and my son Caleb is with his mother.
Why is your child with their grandmother as opposed to the mom?
The mom passed away, ma'am.
All right, this is what the court is going to do. There's a $1,500 fine, 6 years deferred
Judge,
adjudication.
I apologize. Regarding the fine, I
Oh,
have discussed that.
I probated it.
I was just about to ask.
No problem.
Thank you.
$1,500 fine probated, affirmative finding of family violence, 6 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs. Have you ever used drugs in the past?
It's been quite a while, but yes, I have.
And what has that been?
It ranges, ma'am, from marijuana to cocaine to methamphetamine, but it's
All
been
right.
quite a while.
Do you have any family support here in San Antonio?
I do, ma'am.
Who do you have as your support system?
My mother, my brother, 2 brothers, I'm sorry. And they're great and they're involved in the church and they're actually very, very positive about the only positive people in my life.
All right, how far did you go in school?
Graduated high school.
All right, what are you planning on doing with the rest of your life as far as employment?
Ma'am, I do have, like I said, it has been a while, but I have some skills in different regions, but the last job I did have, well, to answer your question, I'm sorry, I plan to, like I said before, just eventually very quickly become a productive member of society. My brother's waiting on me to get out so he can he remodels homes and I'm good with my hands. I also, done electrical work in the past, construction, stuff like that. But, I just plan to be a good father to my children. That's one thing that's really been eating at me, and also change my life fully so that I can bring joy to my mom, because I brought a lot of tears to her face. I turned 37 years old here, incarcerated, so I'm just tired of coming back in and out. I really, really do plan on changing. I'm not just saying that, that's what I feel.
All right, so as previously stated, there's 6 years deferred adjudication, $1,500 fine probated, affirmative finding of family violence, regular reporting by Zoom or in person, regular random UAs, in custody. I want a TAP evaluation and referral to felony drug court. Follow recommendations, no contact with Desiree Molina, proof of employment within 30 days of release, no employment as a home health care or with minors, no unsupervised contact with minors, 200 hours of community service restitution. 100 of those hours will be waived upon completion of parenting classes. The other 100 hours will be waived if he completes some sort of certificate in trade school. And there'll be field visits 1 time per month for 6 months. Probation, is there anything else? Is there anything else you need from the court to be successful? All right, did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it?
Yes, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, off the record, here's the thing. You say you want to get your life together because you want to be in your children's life. You want to stop disappointing your mom. You're going to have to stick to that. If your plans are not to be a better person, then don't even, keep going into your children's lives, breaking their hearts. You understand?
Yes, ma'am.
All right, good luck to you, okay?
I appreciate you.
You're welcome. Okay. Who's here on Inaosa? Mario Inaosa. Hello. Hi, thank you for dressing appropriately for court.
Yes.
All right, where are we on discovery?
So there was, you go to discovery, there's a lot of videos. I requested a deadline, if I could have something maybe in the 3rd week of November or 4th week of November.
Okay, let me look. We can put it on November 21st. And are you feeling okay? All right. All right, we're going to come back on November 21st. That's going to be your plea deadline date.
Yes, Your Honor.
Thank you. Norma, on Inaosa, it's November 21st for plea deadline date. You're welcome. All right, take care of yourself.
It seems like Dana needs to come back. I don't do my name on anything.
See, there you go.
So.
And I write in
I
everything.
know, and I even looked at your notes from the trial and everything. Not
Mhm.
one time did it say my name.
Yeah, and I'm gonna look just to be sure.
But I wasn't originally, I was just sitting there with them and I think you said my name to the jury because I was sitting there.
Yes.
But I don't think I was ever formally appointed, but that's why I was afraid that maybe I was, and that's why I filed that motion, which might have triggered getting my name put on the, but, and I don't mind, like I said, helping Charles, but I just, well, didn't want to be like. Okay, so I'm not gonna worry about it, Judge. If I'm here, that right, and so I'm helping. Hey, happy early birthday.
Oh, thank you. Well, you know, I celebrate the entire month.
I know. Next tomorrow, starting tomorrow.
Yeah.
All right, bye guys.
Bye. Good seeing you.
Good to see you.
Who's here on Karen Garnica? Karen Garnica. All right, you need to call your attorney. Who's here on Amanda Drummond? Amanda Drummond. Okay, why do I have this? Okay. All right, can you give me that cause number, please? Uh-huh. I think maybe they gave me two files. No, it's November 14th. Okay. Who's here on Eric Kelly? And then after Eric Kelly, it's going to be a plea on Acosta. Is the attorney here for Acosta? All right, we'll call you next. So where we are, I know this case had a lot of moving parts.
There's other moving parts, but we're only here on one case today.
All right.
And I think he's set in the next week or two on all of them together.
Yeah, he's set on November 14th altogether. So everybody just, is there anything I need to know?
Judge, we're here because he's, as you can tell, in custody, and
Yes.
there was a remand. He picked up some misdemeanors out in Guadalupe County
Yes.
that are currently pending. He's already posted a bond for those. He's been on bond with us for, well, the record will show when that was, but he's always been good about reporting and taking care of his business with us. So.
And what were the misdemeanor cases?
Unlawful carrying of a weapon, possession of marijuana 0 to 2 ounces, and violation of bond or protective order, Your Honor.
Yeah, and he's not certain where that materialized from today, does he?
With the violation of the bond and protective order?
Yeah, he doesn't-
All right, because I take that very seriously.
Don't have one.
No, I mean,
So,
if there's a protective order and he violated it, we're gonna have some issues.
Your Honor,
Yes.
was there a prohibition on the possession of firearms as part of his bond conditions for 2024 CR 010117?
I'm sure there would have been.
Because if so, that might constitute the violation bond order.
All right, so there's that. So if y'all want to, has anyone looked in that? Because my understanding, I think the co-defendant was here. Okay. All right, so y'all want to see if that's really the only violation of the bond condition? And if there wasn't a violation of a no contact order?
So here's the thing, Judge, we're trying to figure out is, it's listed as a Guadalupe County case. It wouldn't be a Guadalupe County case if it was a violation of the order here. It would be a Bear County case. So I asked him, well, do you have some kind of protective order going on out there in Guadalupe County? He said, no. So we're trying to figure out how he's got a Guadalupe County case when he doesn't know of a protective order being out there.
All right, could someone look through his conditions? Just have a seat and we'll come right back to make sure I have all of the information. All right. Acosta? I think you may be the last person who was able to get a trial court certification. We run out. I see you wearing your I voted sticker.
It's John and I were voted at lunchtime.
Oh my God. I went on the very first day and the lines were so long, it took me 30 minutes. Oh, you and Mr. Cox are matching. All right, court is calling 2024 CR 007532, State versus Dino Acosta. Can I have parties announced for the record for the state?
Andrew Harry Salem.
Defense?
Brandon Lopez.
And are you Mr. Acosta?
Yes, ma'am.
Counsel, have you received all of the discovery? Did you review it with your client?
We did, Your Honor.
Mr. Acosta, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
I did, and I do understand it.
Did you review the true bill of indictment with your attorney? Did you understand it?
I did, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor. We have the habitual offender enhancement application.
No, objection, Your Honor.
All right. Did you review the court admonishments and waivers with your attorney?
I did.
Did you understand it, sign it in all the appropriate places?
I did, Your Honor.
Did you understand you're charged with theft of property, $30,000 to $150,000? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
I did, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I understand, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
I do, Your Honor.
Did you understand that today, I'm sorry, just one second. Did you understand that by entering that you were giving up those rights?
I did, Your Honor.
And did you intend to give up those rights and enter into a plea today?
I did, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine?
I do, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Acosta, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
I did, ma'am.
Did you understand it?
I did. It was
According to the plea, punishment is to be assessed off the record. State, are you opposing both his applications for community supervision and deferred adjudication?
Yes, Your Honor.
All right, so we're back on the record. So according to the plea bargain agreement, the state is asking that your punishment be assessed at 6 years in the prison. There's a $2,000 fine. They're opposing applications for community supervision or deferred adjudication. They're asking that restitution be paid to the complainants in this case. Did you understand that to be the plea?
I did, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
I did, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I did, Your Honor.
Counsel, have any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
Should be contained in Exhibit 1 and attachments, Your Honor.
No objection.
All right, states, you may be excused.
Your Honor.
Did you review the waivers and stipulations with your attorney?
I did, Your Honor.
Did you understand it and sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
I do, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
I did understand, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. We're off the record. So the state is opposed. If you would like, I can reset this for, a shorter time and make a decision based upon any criminal history that the state wants to present to me and any witnesses that you have to present. Otherwise, it will be 8 weeks.
Your Honor, I'm gonna choose the latter on a oil platform offshore, and so the longer time frame for the reset would be beneficial to scheduling coming back.
All right, Ms. Ferguson. I need a date for PSI and TAP evaluation. All right, December 19th.
And Your Honor, as far as the PSI and the TAP, are those available via Zoom, do you know?
Ms. Abrams, are they able to do that by Zoom? All right, we'll do it by Zoom.
Thank you, Your Honor.
You're welcome. Is there anything else?
Nothing further, Your Honor.
All right. So, was your mom a big fan of Dean Martin?
That's where it comes from.
Yes.
Ma'am.
All right, see, I like Dean Martin too.
I didn't pick up on that.
No, she nailed it right in the head.
Thank you, Your Honor.
You're welcome. Thank you.
Thank you. You have a good day.
All right, you too.
And Your Honor,
Yes,
on Mr. Kelly,
yes.
I was able to find an order as a condition of bond of no possession of firearms.
Okay. All right, then we will take that matter up. Mr. Kelly, come on down.
No alcohol, no firearms. But it doesn't explain why he's got the charge. Guadalupe County, not very.
Oh, hey,
So
I don't know what's happening in Guadalupe County. All right, and I'm assuming you're only here on the 2024.
7.
Yeah. All right, court is calling 2024 CR 010117, State of Texas versus Eric Kelly. Can I have parties announced for the record again for the state?
Andrew Harris Edelman.
Defense?
Robert Behrens for Mr. Kelly.
And are you Mr. Kelly?
Yes, Your Honor.
All right, defense counsel has filed a motion to set bond. State, have you had a chance to review the motion?
Yes, Your Honor.
All right, is there a proposed agreement?
Yes, Your Honor.
And what is the proposed agreement?
$150,000.
All right, and defense, what are you requesting?
Well, Judge, I mean, we're willing to reinstate, stay on the bond if the court allows us to, but if you.
What was his previous bond amount?
100. So if you decide to increase it, of course, we're glad to accept the state recommendation. You can't just stay on the original.
All right, the court has reviewed the defendant's history, but since you've been in custody, there are a few questions that I need to ask you. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Eric Kelly.
All right, how long have you been in custody?
Approximately 2.5, maybe 3 weeks.
And you're housed in general population?
Yes, ma'am.
Have you had any prior mental health issues?
As far as going from chemotherapy, from radiation treatment, does not have anything like diagnosed.
Okay. All right, and do you have a place to live? Who would you be staying with?
My mother and father,
All right, have you called them and asked them if you can stay?
they're already aware of it. Just no one can stay with them.
No. Did you call them and ask them if you could stay?
I haven't called them as of today, but I can call them, but they will agree with it.
He was already living with them. They
Okay,
have a small plot of land somewhere between here and Seguin.
all right, this is what the court will do. The court will set your bond at $125,000. All previous conditions to remain. And he is in Seguin, you say?
Well, what town do you live near?
It's called Sandy Hills.
I mean, where is that?
It's in between Seguin and San Antonio.
off of 1117 Tower Road.
All right.
876.
I'm gonna do GPS. Are you employed?
Yes, ma'am.
All right, I'm gonna do GPS, waive fees. And I'll do partial GPS for employment. Is there anything else?
I don't think so, Judge.
All right, Norma, if you can make sure he gets a reset form, he's already set for November 14th. All right, thank you.
Thank you very much.
All right,
Your Honor, may I be excused?
yes,
Thank you, Your Honor.
just a moment. Let me put this in the system. Yes. Okay.
Ready?
There you are. Thank you.
Thank you so much.
Red is your color.
Thank you.
You always say when you see people in their color, you should let them know that's their color.
Thank you. I appreciate it.
All right, thank you. All right, and Norma, if you make sure that for the case that Bob Barron's just had, that all of them are set on the 14th. Okay. And that last plea we did, can I have that? I'm sorry, I needed to write something on it. Yes. Mhm. Oh, yes, because whatever the previous conditions, they still are in effect. Okay.
He's back now.
Garnica? And is Martin Torres on the docket today or no? Martin Torres. All right. Here's some business on that. All right. So it's been dismissed. All right, where are we on this case? Why are we here? I think we have a violation report.
Yes, Your Honor.
All right, it says you're using alcohol.
I was under medication. I was taking NyQuil and then some cough drugs such as Robinson and Vicks.
All right, so here's the thing. Everybody knows when you're on a bond or probation for a DWI, you can't drink NyQuil. Everybody knows NyQuil has alcohol. I don't know anybody on the planet except for newborns who don't know that NyQuil has alcohol in it. So you know you're not supposed to be taking that. Do you understand?
Yes.
this, what do you want to do with this violation report?
I wasn't sure, Judge, if the substance abuse treatment had been ordered after the last report. If it hasn't, the state would ask that that be added on.
Okay. All right, so what's going to end up happening is there's still going to be full house arrests. You're still going to continue with the in-home breathalyzer, no driving. There's still going to be random testing, and I'm going to order the substance abuse treatment outpatient. I'm going to ask that the fees be waived. There's going to be 120 sober meetings in 120 days. Do you understand?
Yes.
Do not come back here again saying that you drank NyQuil or whatever you're drinking. You had better start looking at bottles and seeing if there are alcohol that is in them. And if you have an alcohol problem, I can tell you that people who have alcohol problems or substance abuse issues, if you let the doctor know that you're in a treatment program, they will find something for you to take that does not have addictive substances in them or alcohol in them. Do you understand?
Mhm.
Is there anything that you do not understand that I'm telling you?
Mhm.
All right, do not come back here again for this. Do you understand?
Yes, ma'am.
All right, and thank you for dressing appropriately for court.
Thank you,
Take
sir.
care.
All right. All right, thank you. Who's here on Espinoza Ruiz? Who is here on Juan Ramirez? Paul Ramirez? All right, all right, come forward. We'll take up Juan, then we'll take up Paul. Court is calling 2024 CR 009140 State versus Juan Daniel Ramirez. Can I have parties announced for the record for the state?
Jason Garahan, you're on.
Defense?
That's the second of it.
And are you Mr. Ramirez? Counsel, have you received all of the discovery?
I had it.
Did you review it with your client? Court will find that the state is in compliance with discovery. And my understanding, there's no application?
That's perfect.
Did you review the indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
There's not really, was there any enhancements on that?
Yes.
We'll wait.
Any objection? And Maria,
Yes.
whenever you need a break, just let me know. I can't see over my computer, so I can't see your face. All right, did you review court admonishments with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with tampering with an electronic monitoring device as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Ramirez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 8 months in the state jail facility. There's a $1,500 fine and no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, sir.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. So exhibit number 1 with all this attached. No objections.
Did you review, state you may be excused? Did you review the waiver and stipulations with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, we are.
Anything you wish to say on behalf of your client?
Other than giving credit for time served.
All right, the court is finding you guilty. The court will sentence you to 8 months in the state jail facility, give you credit for any time served. There's a $1,500 fine. Time and money will run concurrent.
Thank you.
All right. Did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. This is nonsense, right? You're living with your mom. If your mom doesn't want your girlfriend there, then she doesn't stay there. I don't know what you don't get about that. And you are, how old are you?
42.
You need to have your own place if you want to be bringing your girlfriend somewhere. You understand? Do better. How old are you?
42.
42? All right. I didn't hear you the first time. I didn't know if you said 41 or what. Here's the thing. 42, I can tell you this because I'm in the twilight of my life. At 42, time goes by so quickly. You're going to wake up and find that you spent a majority of your time at the prison. If you don't want your life to be at a prison forever, then you're going to have to change your ways. And if your mom accepts you to live in her household, you really need to apologize to her, because I'm sure she had people come knocking on her door at midnight because you've cut off a monitor. You understand? All right, good luck to you, okay?
Thank you.
You're welcome. All right, now we have Paul Anthony Ramirez. And after Paul Anthony Ramirez, it will be Gil. Court is calling 2024 CR 009393, State of Texas versus Paul Anthony Ramirez. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Attorney Bill Simmons for defense.
And are you Mr. Ramirez?
Yes, ma'am.
All right, they're letting you guys have rubber bands and stuff at the,
No.
I think that's considered contraband. So you may want to check, because otherwise they're going to take away your privileges
Okay.
for using that, okay? Read, I don't know if they still give out handbooks at the jail, but if they do, you need to read that, because the wrapping around your hair, that's considered contraband. All right, counsel, you've received all of the discovery?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ramirez, did you review the application for community supervision?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
I know you're waiving count one and proceeding on count two.
Any objection?
No objection, Your Honor.
All right, Mr. Ramirez, did you review the court admonishments and waivers with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand in count two, you're charged with possession of a controlled substance, penalty group 1, 4 grams to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you could both sign that. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
All right, and I'll let you sign that.
Just for the record, this is the appeal form that we said we discussed prior to us entering the plea, saying that we're not going to appeal the case if the judge follows our plea agreement. You understand? Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ramirez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 4 years in the prison. State recommends community supervision. They're taking in consideration County Court Cause number 636209. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counselor, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years and there be a TAP evaluation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State exhibit number 1 with all of its attached.
No objection.
All right, and state you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney?
Ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We just pray the court to follow the plea agreement.
All right. How old are you?
27.
Do you have any children?
No, ma'am.
So who do you live with?
Right now, my mother.
All right. Do you have employment?
No, ma'am.
When's the last time you were employed?
2017. 18.
So how are you supporting yourself?
I just got out of prison.
All right. And who is Faith Contreras to you?
That's a family friend.
All right. So she is no longer a family friend because I'm gonna order that you have no contact with her. You understand? Your situation in reading these facts could have turned out very badly. It doesn't go well when it's 2 people get in a car, there's a sword in the car, and people have drugs. You understand?
Yes.
I mean, no, that's what they said. The police pulled you over and there's a sword in the vehicle. And you all have drugs. And obviously somebody was high because there was a pipe in the vehicle as well. So you get pulled over, you all are driving around with a sword. It's not the purge. So there's no reason to have a sword. You understand? How far did you go in school?
10th, 11th grade.
Why did you drop out?
Well, I left 6th grade. I
Why?
got tried as an adult.
I'm sorry?
I got tried as an adult when I was 14.
Ah, okay. Wait, 6th grade, that's 14 years old now?
That's how old I was. 6th, 7th grade.
It's, Your Honor, not believe it. He's,
No, I'm just wondering.
background's been pretty, but he was tried as an adult, I believe, at 14, and he was he had been locked up since he was 21 for that same offense.
Okay. Do you want to go back to prison?
No, man.
All right, so that means that even though however you ended up where you've ended up, dropping out at 6th grade, being tried as an adult, here's your shot to better yourself and not spend the rest of your life in prison, okay?
Sure.
So this is what I'm going to do. Sentence you to 4 years in the prison, suspended and probated for 6 years. Take in consideration County Court Cause number 636209. There's to be regular reporting by Zoom or in person, regular random UAs, field visits 1 time per month for 6 months, proof of employment within 30 days. There's to be no employment as a home health care with minors. I'm going to order 200 hours of community service restitution. If he obtains his GED or some type of trade school certificate, 100 hours will be waived. There's to be no contact with Faith Garcia Contreras. There's to be a gang evaluation. How often were you using drugs?
Just recently,
All right, here's the thing. You need to be honest with me because
I just barely got out of prison, so
okay.
It was only like a matter of like 3-4 weeks.
All right, and how often were you using though? You get out of prison, you meet with this Faith Garcia Contreras person. How often had you been using? When you
like every other day.
All right. So what we're gonna do is we're gonna do a TAP evaluation in custody. Let me just tell you, the TAP evaluation in custody takes about 2 weeks. I don't know much about his criminal history other than what I see in the system. I'm also gonna see about a referral to felony drug court. They may not accept you for gang affiliation reasons, you understand? Right. Probation, is there anything else? Is there anything else you need from the court to be successful?
No.
All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak with an attorney. Do you understand?
Yes, ma'am.
We can go off the record. So here's the thing. I know there are some things you may not understand since you've been locked up since 6th grade. But this is what I want to tell you, and I want you to listen to me very closely. Obviously, the state wants you to succeed. Your attorney wants you to succeed. I want you to succeed. That's why I gave you this chance on probation. But you got to want it for yourself. You understand?
Yes, ma'am.
Now, in Texas, there comes a point in time, if you pick up another case, you're habitual. That means that your minimum is 25 years. So you're going to have to be on the straight and narrow. And anytime you think about doing something, you know, hanging out with gang members, I understand at the age of 6th grade that sometimes when you go to prison, you have to affiliate in order to survive and have a not decent life at the prison, but be able to come out hopefully safe physically. I understand that, but you're going to have to put that behind you. And do not get any more facial tattoos. And the reason why I tell you that is because when you're trying to get employment, when you're meeting people, they will see that and they will think certain things. You understand?
I know, Your Honor.
All right. And in this court, communication is key. If you need something, let your probation officer know. If you feel they're not addressing it, you can always come back to the court and we'll see what we can do. You understand?
Yes, ma'am.
All right. Good luck to you. Okay.
Oh, I'm sorry, Your Honor, and
Yes.
he's been in custody for about 120 days or so. Would the court give that consideration and letting him get out to take his TAP evaluation or do TAP in custody?
No, he's going to do the TAP in custody. And let me explain to you why I want you to do the TAP in custody. Because immediately when you got out of prison, you started using a lot of drugs. And I know when people are locked up and they're released, they say, you know what? I'm never going to be back here again. I'm sure when you got released out of prison, you're like, I'm going to be on the straight and narrow. I'm not going to let this happen again. I will not put my life in jeopardy that way. But immediately when you got out of prison, what did you do? You got with this Faith Garcia Contreras person, and you all are driving around in a vehicle with a sword in meth. So many things could have went wrong for you guys. You understand? So this is to help you help yourself. All right?
No.
All right. Good luck to you.
May I be excused, Your Honor?
Yes.
Thank you.
Thank you. Christopher Gill? Hello.
Hello.
Thank you for dressing appropriately for court. Court is calling 2024 CR 007-923, State of Texas versus Christopher Gill. Can I have parties announced for the record? State,
Tony Arriola.
defense.
Guillermo Lara for Mr. Gill, Your Honor. Good afternoon.
Good afternoon. Are you Mr. Gill?
Yes, I'm Mr. Gill.
Probation, this is an application. Counsel, have you received all of the discovery?
Yes, Your Honor.
Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the application of community supervision with your attorney?
Yes, I did.
Did you understand it and sign it?
Yes, I did.
Did you review the true bill of indictment with your attorney?
Yes, I did.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor. I believe there's an amendment that was made on that.
All right, we'll get to that.
Yes, Judge.
State, are you proceeding on the indictment as presented?
We're not, Your Honor. State is orally amending the indictment. Specifically, the first prior. It currently says that the conviction was on the 3rd of November, 2022. It should say on the 14th of November, 2023.
All right, defense, any objection to that amendment?
No objections, Your Honor.
Mr. Gill, do you have any objection to that amendment?
No.
Do you understand that's a substantive amendment to the indictment?
Yes.
And do you understand with that amendment, your attorney has 10 days to prepare for trial?
Yes, ma'am.
Are you waiving those rights?
Yes.
All right. Then the indictment is so amended. Mr. Gill, did you review the document entitled Court Admonishments and Defendants Waivers?
Yes, I did.
Did you understand it and sign it in all the appropriate places?
Yes, I did.
Did you understand you're charged with driving while intoxicated third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Gill, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 4 years in the prison. There's a $1,000 fine. State recommends community supervision, and there's to be restitution, if any, to Barbara Estrada. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That's correct, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver with your attorney? Did you understand it and sign it in both places?
Yes, I do.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor, not urged.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 200 hours of community service restitution, DWI intervention, victim impact panel, ignition interlock for half the term, 30 days house arrest in lieu of 10 days in the Bexar County Jail. Did you understand that those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers State's Exhibit 1 with attachments.
No objections, Your Honor.
Did you review the waiver and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, I do.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge, I just wanted to start off by saying that initially when Mr. Gill started this process, he did file and request a court-appointed attorney. He is indigent, and throughout the process, he hasn't had the funds to pay for my representation. I advised him that that's fine. I will waive the fees. I just wanted to put that on the record for Mr. Gill, Judge. And I wanted to explain a little bit about the scenario that evening, Judge. Mr. Gill had previously had DWI convictions back in 2023, as the court is aware. That evening, he was in an argument with his then girlfriend, who he had been in a relationship with a few months. Again, it was a toxic relationship. You work too many hours, you don't love me, you don't work enough hours, you don't love me type of situation, Your Honor. He's not blaming that and making excuses for why he did what he did, but he wanted the court to be aware that he was doing well, and he let it get the best of him, and he went back to abusing alcohol. And again, he wants the court to be aware of that, because again, he wanted the court to be aware that even now, as far as being represented, what he's represented on paper with respect to the court, I'm not sure if the court received it, but he was asked by this court to do 120 days of Alcohol Anonymous, and he completed those successfully, Judge. He's had no violations whatsoever in the time that he's been supervised from the date of the arrest until now. He's done his UAs, Judge, weekly as the court asked and ordered. He's come out negative in each and every one of those exams as well, Your Honor. He has finally been able to secure employment. He's working right now, Judge, as a computer tech, 40 hours a week. He's allowed to do that from home, and that's part of the reason why we're asking this court to allow him to continue doing that. And if a TAP is ordered, for him to be allowed to do that while not being incarcerated, Your Honor. Again, he's been compliant. He's showed this court that he can comply with the court's orders. He's asking this court to give him an opportunity. He knows what he did was wrong, and he's just asking this court to allow him to continue showing the court that he can follow the court's rules and, again, abide by the court's requirements. So we're asking the court to follow the agreement, Your Honor.
And you want to speak to GPS?
Yes, Judge, and he is aware that he is going to have GPS, and we're asking this court to allow him an opportunity within 48 hours to get that equipped so he can be, again, at his residence. I believe you mentioned that you're going to be moving.
Yes, we are looking into moving in possible because the lease is over in maybe 2 months. So
Okay.
just wanted to let that be known.
All right. So do you have any children?
No, I don't.
So what do you do in your spare time?
Spare time, lately since my mom's been working a lot, I've been taking care of my little brother. That's one thing I wasn't able to go ahead and focus on, especially with the whole relationship thing. So since we cut ties, it's really been all about him. And I tried looking for a job. Just I hadn't gotten it. And this one, my buddy went and told me about it, and he was able to go ahead and squeeze me in, which I thank God for that.
Okay. All right. This is what the court is going to do. Court is finding you guilty. The court will sentence you to 4 years in the prison, suspended and probated for 4 years. $1,000 fine, probated. restitution to Barbara Estrada. Was any insurance paid to that?
It was paid in full, Your Honor.
All right, so if you provide that information to probation, then that can be taken care of. Proof of employment within 30 days. No employment as a home healthcare provider with finers. DWI intervention, victim impact live, ignition interlock for half the term. DWI education, regular reporting by Zoom or in person, regular random UAs, TAP evaluation out of custody. Probation, if TAP recommends inpatient treatment, will start with intensive outpatient treatment. I'm going to order 20 days on GPS in lieu of 10 days in the Bexar County Jail. That's going to be full GPS, so you will be at your house for 20 days. You understand?
I understand.
And the reason why the court is allowing that is because I know that there's an issue with overcrowding at the jail and also other issues. So that's why I'm allowing you to do 20 days GPS and 200 hours of community service restitution. Is there anything else from either side with regards to sentencing?
No, Your Honor.
Judge, the only other request, Mr. Gill asked if the court would consider allowing him to use some of the AA meetings that were an hour each meeting, and replace some of the hours that he owes for community service. That was the only last request.
No. Here's my thing with community service. With community service, if there is something that would help you improve yourself educational wise, sometimes I'll take those community services and in exchange for doing something like that. For example, maybe you want to get a cybersecurity, degree or go to trade school for that. I'll consider taking in consideration some security, some community service restitution hours for that. But just for you doing sober support meetings, no, because I find that people start enjoying sober support meetings and you get to meet people. And I do, when I order the 120 days sober support meetings or 90, I'm hoping that people will start getting back on track with their sobriety and enjoying it. So I hope you enjoyed it.
Yeah, I was actually say I did meet some a couple people that I got numbers from. So yeah,
Okay, that's awesome.
Gonna stay in contact with them.
All right. And I will tell you, when people successfully complete that, I always get notation from pretrial services that they completed. So I did receive that from you. That's why I didn't order you to do sober support meetings. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I do understand.
All right, we can go out yes. Oh, thank you. Let's do field visits. One time per month for 3 months. All right, so off the record, here's the thing. You cannot let other people interfere with your ability to maintain your sobriety. You understand? Because otherwise you're going to be right back here. You may end up killing someone. All right, if you need anything, let probation know. If you feel as though they're not addressing it, you can always come back to court, okay?
Thank you.
All right, thank you. And counsel, just make sure that they get documentation that that restitution was paid by the insurance company.
Yes, Judge. I believe he emailed it to me, so I should be able to get that to him pretty quickly.
All right.
Thank you,
And
Judge.
are you on the appointment wheel or no?
I am not, Judge.
Okay. Well, thank you for continuing to represent him.
Yes, Judge. I saw that he was making a lot of progress, so I wanted to stick with him.
Oh, thank you.
Thank you, Judge.
Have a good one.
Thank you.
Judgment take.
Yes. All right. David McLean, who do you have? All right, if there's anyone who has a client that it's not a plea, then I can take you up. The court reporter is just taking a break. All right, who is it?
It's Robert Castillo. This is on the motions.
Oh, yeah, okay.
No worries. And this is the one, Judge, we had talked about getting pretrial services in the Horn because they didn't understand your order about his working versus needing to be home for other purposes.
Okay.
Thank you.
And are you all, do y'all have any agreement on any of the motions or no?
I think so.
All right, do y'all wanna,
There's just one order where I objected the language, Judge.
okay. Oh, well, that's gonna be very simple. Okay. Now I jinxed it by saying that's gonna be simple and quick. I know, I forgot. Yeah. Last minute, please. Mhm. Thanks. That's okay. Thank you. But Deputy Laura, we will not be here tomorrow. Because it's Friday Eve. Oh, it is. Look at me saving you from trick-or-treaters. Who is Lauren Ricketts? Okay. All right, David McLean. Miss Ricketts is here, Officer Ricketts. So on your guy, we'll find out what the issue is with the pretrial services.
Okay.
And your guy is Robert Castillo?
It is Robert Castillo. You want him up here, Judge?
Just a minute, she's connecting to audio.
No problem.
Oh, no, you can remain. She's just connecting to audio. Hi. Oh, she's still connecting. Hi, Miss Ricketts, Officer Ricketts, can you hear us?
They gave it an X.
Okay.
There she goes. She's connected now.
Oh, are you connected now? I think she can.
Officer Ricketts, can you hear the court?
See, I jinxed us. I did.
We planned.
Oh,
Yes.
yes. Okay.
Sorry, on my computer, the settings are I have no idea. I'm sorry about that.
Okay.
Can I have that document I just printed, please? And does anyone have a stapler? Say he's in compliance. Oh, we got it. Thank you. I appreciate that. All right, so the first thing we need to address, have your client come up.
Come on up.
All right, the first issue we have is, you say there's an issue with pretrial?
Right. From my understanding from speaking with my client, when we were here last, we modified his bond conditions because he had gotten new employment that was going to require him to work one of three shifts, so it could possibly go 24/7. The original condition of his bond, he has GPS. He's had it since the beginning, no violations, and he's trying to keep it that way. But there's a condition where he has to be home between the hours of midnight and 3 a.m.
Yeah, 3 hours.
All right, so Officer Ricketts, he needs to be home by the curfew that's stated. The only exception to his being home by that time is if he's at work. So if he's at work, he can be at work. But if he's not at work, that's his curfew.
Yes, ma'am. Yeah, Mr. Castillo and we discussed it, and I told him about that, that was fine. He was able to work whatever hours that he needed to work, and that as long as he wasn't able to do any extra duties between the hours of those 3 hours of curfew, that he was only allowed to work during that time.
All right, so that's cleared up.
I think it's all cleared up.
All right, thank you so
I
much.
just want to make sure we're in compliance, Judge.
All right, thank you so much, Officer Ricketts, for zooming in. I really appreciate it.
Thank you, officer. Appreciate
No
you.
problem.
All right, thank you. All right, and the next thing we have are motions.
Yes, Your Honor.
Court is calling 2023 CR 8866 State versus Robert Castillo. Could I have parties announced for the record?
Tony Arriola, the state of Texas.
David McLean for the defense.
And are you Mr. Castillo?
Yes, Judge.
All right. So let's go through your motions. The first one is to have the court reporter make a record. I'm assuming there are no objections to that.
No objections.
Okay.
Thank you, Judge.
So that will be granted. Next one is motion for discovery and inspection. All right, so we'll go through the numbers. So number one, any statement by any party or witness.
No objections.
So one is granted. Number two, any objections?
Closed on me, Judge.
Oh, well, number two has to do with if there was some testimony given to the grand jury.
No objections.
Number three is all the names and addresses of individual witnesses the state intends to call.
No objections.
All names of witnesses that you're going to call during the sentencing phase.
No objections.
If applicable, the name of any confidential informants.
No objections.
Names, rank, and badge numbers of all police officers.
No objections.
All documents, manuals, or other tangible things the state or any witnesses intend to introduce, rely on, or refer in testimony.
No objections.
All right.
With this one, I did object to the proposed order on passing this motion.
Yes, Judge, and I think Antonio and I talked about this. There are, I believe, three things in the motion that he was talking about. The first goes to that second paragraph where it says it's further ordered that any evidence within the scope of the items granted above be provided by the state to defendant's attorney at his office, my address, on or before 5 p.m. 20 days prior to the next trial setting after the signing of this order. I think that what we're trying to track here is the 3914 language, but at the same time, the state's attorney is arguing, why don't we just have 3914 or say in accordance with 3914 Texas Code of Criminal Procedure? Frankly, I don't really have an objection to that.
All right.
So if we could change that language, I don't know if we would just want to interlineate or if you want me to draft another order. However, the
Do
court,
y'all want me to then just to remove it is ordered? And just place, you all can write in that you will abide by the rules?
That's fair.
that's fair, Judge.
Okay. So if you want to just scratch through and then I will sign it.
Do that.
Say in accordance with 3914.
Second paragraph, you can get rid of the whole thing, okay? Okay.
Yeah, this is the last thing.
Judge, the last language that we are talking about here on this order talks about that if any of the ordered items are not produced in violation of this order, that they shall be excluded from evidence in this case offered by the state.
Well, that's really for me to make a decision.
And that's why we're trying to get that decision now. And the reason we're doing that is because, as the court knows, everybody has to prep up for trial, get everything ready to go. And you get to the day of trial and all of a sudden it's like, oh, we've got this brand new expert that we didn't disclose.
No, here's the thing. I don't know if there will be something new. So just for me to blanketly say that I'm going to exclude the evidence, I don't know. It may end up being one sheet of paper or something. And what if it's a paragraph? Maybe I'll exclude it, maybe not. I don't know. I have to know what it is.
My purpose of doing this is more akin to the civil rules, honestly, in that if it's not produced, you can't use it. I know that's not exactly how the criminal courts are interpreting 3914. They're actually imposing on the prejudiced party to have to move for a continuance. That has been pretty much the rulings that I've been seeing.
No, that's not what I do.
Okay.
So here's the thing. I'm not going to blanketly say that I'm going to exclude evidence. We'll just take it up if that were to happen.
Okay, Judge. Let's just interlineate that paragraph, scratch that out, and then I think we're good.
All right. And the next paragraph has to do with the viewing and visual inspection. Are there any objections to any of that?
With this one, Judge, I think we've been doing that up until today. My only concern is the 10-day deadline. I don't want to agree with it if it's not reasonable for any of my witnesses or law enforcement witnesses.
All right, with the 10 days, counsel?
Okay. We can see if I can, way we can recraft this.
Do you want to say, let's do this, if you are in agreement, counsel, we'll just say during normal business hours at a mutually agreeable time. And if y'all can't agree on a time, then you all come to me.
Sounds good. We'll just scratch that 10-day language.
Okay. All right. The next one we have is motion for discovery of Exculpatory evidence. I'm assuming there's no objection.
No objections, Judge.
Then we have another motion for discovery. With regards to witnesses. All names and witnesses. State intends to call at trial.
No objection.
Is that this motion, Judge?
Yes.
Right, perfect. Okay.
All right, number 2.
Is this motion for witness list?
This is this one. Are you in agreement with number 2?
I agree with number 2.
Number 3?
Yes.
Number 4?
State agrees.
Number 5?
State agrees.
Number 6?
State agrees.
7?
Agreed.
8?
Agreed.
All right, statements. B.
The state agrees with all 8 requests.
Okay. C, with regards to warrants.
State agrees.
D, with regards to law enforcement.
State agrees with all 6.
Photographic evidence.
State agrees with all 4.
F, physical evidence.
State agrees with all 5 requests.
All right, G, test.
State agrees to both requests.
H, state's evidence.
State agrees to all five of his requests.
And I'm assuming 1 through 37 is just what is within the body of the motion?
That's correct, Judge.
All right, next, the motion in limine. You all will need to approach. I won't know anything about the motion in limine unless you approach.
We'll hold that a bit.
Okay. And then motion to limit state's jury argument. Just one moment. All right, state's jury arguments. State,
I reviewed the motion, Judge, no objection.
all right. Then that will be granted. And that's numbers 1 through 11. Is that correct, State?
Yes, Judge.
And if for any reason anyone thinks they're veering into something that's in the limitation of the jury argument, just approach beforehand.
Will do, Judge.
Then we have the motion for the witness list. I think this was sort of covered. Is that correct?
It's sort of covered. This one, when we initially filed our 3914 notice, we included a witness list. Subsequent holdings by some of the courts of appeals have come back and said, no, witness list isn't included in 3914. So that's when I filed kind of my subsequent motion for the witness list. But yes, I think it's probably redundant given some of the motions we've already heard.
All right, any objection to the defense's motion?
No, Your Honor.
All right, that will be granted. All right, then we have a motion for production of witness statements. And writings used to refresh recollections. Any objections?
No, Your Honor.
All right, that will be granted. Then we have evidence favorable to the accused. I'm assuming there's no objection.
No objection.
Then we have 4B. That's no need for me to make a ruling on that. You'll
Right.
just need to turn it over if you have it. All right, and then you have assertion of the defendant's rights under 14th Amendment.
Basically, a speedy trial motion, Judge.
Yeah, I mean, I just wanted you to put it on the record.
Not a problem.
All right. So what we will do with regards to that motion, we'll give you a trial as quickly as we can. There are other people who are ahead of you on the jury trial list. Do you understand?
Yes, Judge.
All right. So, Ms. Ferguson, what date for jury trial? And counsel, do you have all of the discovery?
Judge, Tony and I were talking about that earlier today. We do not have any kind of expert reports or designations. Some of the evidence in this case, I think, would require that, but
I will tell you this, what I can do is I can give you all a reset in November.
Okay.
To make sure that you have all the evidence, and at this time, you all will need to do an acknowledgement of discovery.
can do,
So,
Judge.
let's do this. Ms. Ferguson, can you put us for our last day in November? All right, so what we'll do is we'll recall this for November 21st. And that will be the final day for discovery, and you all will need to do an acknowledgement of discovery.
Okay, Judge. Thank you.
All right, and that will also be the last day if you all are going to enter a plea, okay?
Okay, Judge. All righty, we can do that.
All right, thank you.
Judge, thank you. Appreciate
You're
it.
welcome. Jeffrey Schobel. Are you all ready to proceed on the motion to revoke?
Yes, sir.
Court is calling 2023 CR 5765, State of Texas versus Jeffrey Schobel. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
No, not for the defense, Your Honor.
And are you Mr. Schobel?
Yes, ma'am.
Did you review the documents entitled Motion to Revoke Community Supervision and state's motion to supplement pending motion to revoke community supervision with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Jeffrey Scott Schobel who was placed on community supervision in 2023 CR 5765 for the offense of theft $2,500 to $30,000 on September 5th, 2023 for a term of 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 4 in Bear County, Texas, the defendant Jeffrey Scott Schobel did in there failed to report to the supervision officer as directed on September 12th, 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the remaining violated conditions.
Any objection? Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $500 fine?
Yes, ma'am.
I'm sorry, $10,000, no, $500 fine,
Yes, ma'am.
because it's not deferred. Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, is to revoke the individual office community supervision, reform the underlying sentence of 2 years down to 1 year in the state jail facility.
Is that the agreement?
recommendation, Your Honor. Yes.
All right. Are you waiving your right to appeal?
Yes, ma'am.
Are you asking the court to follow this agreement?
Yes, ma'am.
All right. The court will find violation of condition number 4 true. The court will grant the motion, sentence you to 1 year in the state jail facility, and give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. We can go off the record. Why were you not successful?
I got back on the drugs now.
Well, what I'll do is I'll request that you be placed in the therapeutic community. It won't increase the time that you're in custody. So I'm sentencing you to a year. That's the most you'll be in custody, a year.
Your Honor, we actually have over a year. I was gonna just say for the, well,
Well, here's the problem with that.
we're not on the record right now. Yeah.
No. Here's the other problem with that. I can say judgment satisfied, all I want to say. What will end up happening is he's going to be processed at the state jail facility.
Yes, ma'am.
They're still going to pick him up.
Yep.
You understand? So you want your life together, you better start making some changes. When you're released, if you can't find a place to go, you can always come back to court, okay? All right, good luck to you.
Thank you.
You're welcome.
Oh, and for the record, Your Honor, I have printouts of his time in Comal County and Guadalupe County Jail while the MTR warrant was pending. So,
All right, if you'll make sure the clerks receive that.
thank you, Your Honor.
All right, you're welcome. Who's here on Genevieve Castanada? This is deferred adjudication. Oh, it's just regular probation?
Yeah, Judge, this is a regular probation.
Okay, all righty. Let me just change it on the docket sheet. All right, court is calling 2023 CR 1428, State versus Genevieve Castaneda. Can I have parties announced for the record for the state?
Antonio Adriana.
Defense?
Jerry Rutledge Jr.
And are you Miss Castaneda?
Yes, ma'am.
Counsel, have you received all of the discovery?
I have, Your Honor.
And did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Miss Castaneda, did you review the application for community supervision?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
What happened with your eye?
I was in my bunk and there's another inmate. She was trying to get out of the unit for whatever issue she had. And she just.
All right. Did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with injury to an elderly person, bodily injury? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, she has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, she was.
Miss Castaneda, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 5 years in the prison. There's a $2,000 fine. State recommends community supervision. They are taking in consideration 738109. 2024 CC. I don't have a number. It's been scratched through. Or is it, I'm sorry, you know what? I think it's 2024 CC 738109. That's what's being taken in consideration.
Yes, Judge.
There's to be restitution, if any, to Anna Cordova Or is this Cardona?
Cardona, Judge.
Dona?
Cardona.
All right, Cardona and Daniel Cardona. Oh, it's,
Corona, Judge.
all right. All right, restitution, if any, to Anna Corona and Daniel Corona. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Your Honor.
Did you understand that to be the plea?
Yes, ma'am.
All right, did you review the waiver of appeal paragraph with your attorney?
Yes, ma'am.
Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation, 200 hours of community supervision, no contact with the following people: Anna Corona, Corona, Daniel Corona, Stephanie, spelled with a PH, Quach, Xavier McCoy, Andy Viet Pham, Catalina Garcia, Nevea Cruz Quintanilla, and Joe's Crab Shack. And it says at 12485 IH10. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State offer State's Exhibit 1 with attachments.
No objections, Your Honor.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right, anything you want to say on behalf of your client?
Yes, Your Honor. Ms. Defendant does not deny that what the allegations took place. Evidently, it was an altercation between Mr. Corona and the grandson. She was there, that's her boyfriend. And evidently both individuals pulled knives on each other, and then Ms. Corona tried to come in and assist either the grandfather or the step in between. Genevieve intervened by pushing Ms. Corona. She had been working, Judge, as a server at Denny's at Culebra and 410, but since she's been incarcerated, she has lost her job, Judge.
All right. So why would you think that your boyfriend would want you putting your hands on his grandmother?
She put out a gun on me and I didn't get in the way. I was sitting in the car.
No, there's none of that in the stipulations. That does, what they say is there was a fight because Frank, who has prior felony history and was on parole, that he wanted to speak to Jenny because Jenny got in an argument. So Frank thought he wanted to talk to him, but he was like, no, I don't want to talk to you. I want to talk to her. And then a fight breaks out. And supposedly Frank, your boyfriend, was on top of the grandfather. So the grandmother was trying to pull Frank off of his grandfather. And then you pulled her. She fell backwards and hit her head. And they said she was unresponsive for approximately 10 seconds until she finally came to. So basically, you came from the blind side to pull a grandmother off of her grandson. Why would you do that? Why would you think that Frank would want you to do this?
I didn't touch her.
Yeah.
I was pulling Frank up so that we could be,
Yeah.
she did pull it out.
How old are you?
I'm 21 now,
All right. And how old is Frank?
22.
All right. Why would you be with him and he's on parole?
No, no.
Are you on parole?
No, ma'am.
Then why would you hang your start as somebody who's on parole who got you involved in this?
No, ma'am.
Do you have any children?
No, ma'am, I don't.
All right. Well, I'm going to help you with your relationship with Frank because that relationship is over. You're not allowed to have any contact with him. You understand? So while you're on probation, you cannot have contact with him. Do you understand?
Yes, ma'am.
Do you have a place to live?
I do.
Who do you live with?
Well, I lost my apartment. I had an apartment, but since I've been in Fair County, I've been speaking with my sister, and she said it was okay for me to go there.
Does she have children?
She does, yes, ma'am.
What are their ages?
I believe one is like 11 months and the other one is 2.
Yeah, you can't stay with her. So I'm not going to allow you with your violent history to be around little children. So that's not going to happen. So do you have somewhere else to stay? And who would that be with?
My other sister.
Does she have children? All right, so I'm telling you right now, probation is going to do field visits. And if they come to a location and they're going to be surprise field visits and there are children there, that's going to be a violation of the conditions I'm going to set for your probation. You understand? How far did you go in school?
I graduated.
And what are you planning on doing with the rest of your life?
I was supposed to start school back for cosmetology.
Okay. Well, what I can tell you, anything that requires a license, they do background checks, and this is going to come up. You understand? All right. Do you have children?
I don't.
Yay. You're not ready for them yet. All right. The court is finding you guilty. The court will sentence you to 5 years in the prison, suspended and probated for 5 years. There's a $2,000 fine that will be probated. Take in consideration 2024 CC 78109. Restitution, if any, to Anna and Daniel Corona. There's to be no contact with the following: Frank Corona, Anna Corona, Daniel Corona, Stephanie, last name Quach, Xavier McCoy, Andy, last name Viet, Pha, is this RM? Pharm, Catalina Garcia, Nevea, and it's spelled heaven backwards, Cruz Quintanilla, and you're not to have any contact with any Joe's Crab Shack. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Anger management. TAP evaluation out of custody. Follow Rex. 200 hours of community service restitution. I'll deem the community service hours satisfied if she obtains some sort of trade school certificate or if she obtains her cosmetologist license. There's to be regular reporting by Zoom or in person, regular random UAs, field visits, one time per month for 6 months. And there's to be no residing with minors and no unsupervised contact with minors. Probation, is there anything else? Is there anything else you need to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? We can go off the record. Here's the thing. When somebody falls and hits their head, no matter what age they are, that could result in death. You understand? And we could have easily been here on a murder. You understand? Now you're telling me that you got beat up unsuspectingly by someone in your bunk, the same way you were attacked unexpectedly. The complainant in this case, she wasn't expecting that either from you. So now you know how it feels. So you need to go through life and be kind to people and don't react to situations. You never should have been with Frank because Frank, it appears that he doesn't want to change his life. You don't have any parole issues. He does. You need to cut him loose. You understand? And work on yourself, work on your anger management. All you had to do that night, if something was going down, you could have left and called the police. You hear? All right. If you need anything, let probation know. If you feel they're not addressing it, you can always come back to court. Okay? Thank you. You have a dismissal?
Yes, Your Honor.
Yes. Mm-hmm.
It's 73801. Kept saying 109.
Oh, because that's what they have, 109. You want to check?
I'll change it, Judge.
All right.
I trust Normo.
All right. So it's, we're back on the record. It's what's taken in consideration is 2024 CC 738019. Yes.
Yeah. Let's take my copy.
I'd be excused. Judge.
Yes. Thank
Thank you,
you for
Judge.
your patience. Who's here on Artilo Espinoza Ruiz? Trevino, Johnny Trevino? Mr. Guy, you are waiting so patiently. I appreciate it. Is this an application for deferred?
Yes, Your Honor.
Court is calling 2024 CR 5449 State versus Johnny Trevino. Can I have parties announced for the record for the state?
Tonio Arriola.
Defense?
Attorney Alvarez Spello.
And are you Mr. Trevino?
Yes, Your Honor.
Counsel, have you received all of the discovery?
Yes, Your Honor.
Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Trevino, did you review the document entitled Application for Deferred with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Sorry, just give me one moment. All right, everyone, just give me one moment, please. All right, we're back on the record. Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
There you are.
State, are you proceeding on the indictment as presented?
We are not, Judge. We're proceeding on the lesser included offense of attempted tampering.
Any objection?
Objection, Your Honor.
All right, did you understand that the state is proceeding on the lesser included offense of attempted to tamper with evidence?
Yes, Your Honor.
That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering into this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Counselor, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Your Honor.
Mr. Trevino, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it and sign it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of attempted tampering with the evidence with intent to impair. They're recommending deferred adjudication. They're taking in consideration 2024 CR 5448. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be a TAP evaluation, 80 hours of community service restitution, and MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged of attempted tampering, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
State offer State's Exhibit 1 with attachments.
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, but the court will defer finding of guilt. Are we proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we just ask that you follow our plea bargain agreement. In addition to that, since I represented Mr. Trevino, he's been trying to gainfully be employed full-time. He had worked part-time before that. And my understanding in speaking with him is he just got a job full-time and he's a plumber apprentice and he's going to be starting that soon. Prior to that, he worked for his father as a plumber apprentice as well. But I believe this job is full-time and offers him more money, more pay. He understands the charges that are before you, Judge, and he understands that
he needs to follow any conditions that you give him, and most importantly, remain sober at the same time.
All right, so how have you been doing with your sobriety?
Up to today, I have been using.
All right.
I don't.
You're supposed to take it one day at a time. That's all any of us can do, okay?
Yes, Your Honor.
So are you in any type of support meetings? Are you continuing with those?
Okay. I don't go to anything, but I don't need this stuff. I don't have a problem. Like, I won't be not one positive to the whole thing. Like,
And if you're drug tested today?
But that's the only positive.
All right, what's gonna happen if you're drug tested today?
It'll be a positive.
For what?
Meth.
See, so we have a problem.
I
Don't worry.
guess.
Here's the thing.
Sure.
I always know that when people are placed on probation, they say, you won't have any problems out of me. But I don't want you to leave here without getting some help you need to maintain your sobriety. Right now, you're shaky. So we're going to try to help you with that, okay?
Yes, Your Honor.
All right, the court is going to sentence you to 2 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. Take in consideration 2024 CR 5448. Field visits 1 time per month for 6 months. No contact with Jimmy Barrientos. 80 hours of community service restitution. That will be waived if you complete your apprenticeship.
Yes, sir.
We're going to do a TAP evaluation out of custody. Follow all TAP recommendations. If they ask for inpatient treatment, we'll start with intensive outpatient treatment. Let's do a referral to felony drug court. You need to make sure you make the appointments with them, okay?
Yes, sir.
And I'm going to order 90 sober meetings in 90 days. Do you have any children?
No, I do, but they don't live.
How old are they?
I haven't seen them in 2 years, but I pay child support.
Okay, how old are they?
In
Are they
15 and
okay?
10.
I'm going to order parenting classes. Probation, is there anything else? Okay. 2 years, deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, taking consideration 2024 CR 5448, field visits 1 time per month for 6 months, no contact with Jimmy Barrientos, 80 hours of community service restitution. That will be waived if he completes his apprenticeship. TAP evaluation out of custody. Follow recommendations with the exception of inpatient treatment. If the recommendation is inpatient treatment, we'll start with intensive outpatient treatment. A referral to felony drug court out of custody. 90 sober meetings and 90 days and parenting classes. Thank you. Is there anything else you need from the court to be successful?
No.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal?
Yes, sir.
Did you understand it?
Yes, sir.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, sir.
If you need anything, be sure and let us know, okay?
Yes, sir.
All right, good luck to you.
Thank
Thank
you.
you.
You're welcome.
Have a seat.
Yes, and thank you for dressing appropriately.
Thanks. Yeah.
The dismissal, Your Honor.
All right, thank you.
Thank you.
Oh, I'm so sorry. It just dropped. I'm sorry. I would never. I'm not even good at throwing paper airplanes. All right, Moy. All right, and this is a plea to 2 cases?
Yes, Your Honor.
Each time you come before me, you have more and more tattoos.
I'm the only ones.
Yeah. Oh. All right, court is calling 2024 CR 1853, 2024 CR 008966, State of Texas versus Haley Lauren Moy. Moy, could I have parties announced for the record for the state?
Antonio Ariola.
Defense?
Robert Gear, Your Honor.
And are you Miss Moy?
Yes, ma'am.
Counsel, have you received all of the discovery?
We have, Your Honor.
Did you review it with your client?
Yes, we.
Are there any applications?
No, Judge.
Okay. Court will find that the state is in compliance with discovery and each cause number. Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State and 1853, are you proceeding on the indictment as presented? It appears that you are. The evading.
For 1853, yes, we are, Your Honor.
All right, and 8966, are you proceeding on both counts? It appears that you're proceeding on count 1 only.
That's correct, Judge, and we wait count 2.
Any objection?
No objection, Judge.
Ms. Moore, in each of the cause numbers, did you review the court admonishments with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Okay. And the cause number ending in 53, you're charged with evading arrest, detention, vehicle. And the cause number ending in 66, and count 1, you're charged with prohibited substance or item in a correctional facility. That's a 3rd-degree felony. The evading in a vehicle is also a 3rd-degree felony. Range of punishment in each of those cause numbers anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand in each cause number you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in each of these cause number?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe that she does, Judge.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do believe so, Judge.
Ms. Moy, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
And each cause number, the court will find that the defendant has knowingly and voluntarily waived her right to jury trial. And each cause number, did you review the plea bargaining pages?
Yes, ma'am.
And the cause number ending in 53, according to the plea, punishment is to be assessed at 4 years in the prison. There's a $2,000 fine. There are no applications. This will run concurrent with 2024 CR 008966. The state will take in consideration 2024 CR 1854. And there's to be restitution, if any, to Samuel Brazier, Brazier. And the cause number ending in 66, according to the plea, state is proceeding on count 1. Punishment is to be assessed at 4 years in the prison. There's a $2,000 fine. There are no applications. This will run concurrent with 2024 CR 1853. The state will take in consideration 2024 CR 1854. Did you understand that to be the plea bargain agreements in each cause number?
Yes, ma'am.
Did you review the waiver of appeal paragraphs in each cause?
Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, in either cause number, has there been any such motions?
There have not been, Judge.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest?
No contest.
State in each cause number, do you have any evidence?
Yes, Judge, state offers State's Exhibit 1 with attachments under each cause number.
Defense is reviewed, Judge. We have no objections.
In each cause number, did you review the waiver and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police report? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same for sufficiency.
Yes, ma'am.
All right, in each cause number, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, we are, Judge.
Anything you wish to say on behalf of your client?
Judge, we just respectfully request that the court follow the agreement with the state.
All right. Then what the court will do is in the cause number 2024 CR 008966, court will find you guilty, sentence you to 4 years in the prison, give you credit for any time served. There's a $2,000 fine. Excuse me, Deputy. All right, what the court will do, and that cause number, the court will sentence you to 4 years in the prison, give you credit for any time served. There's a $2,000 fine, time and money will run concurrent. This will run concurrent with 2024 CR 1853. I'll take in consideration 2024 CR 1854, and I'll ask for the therapeutic community. The therapeutic community doesn't increase the time that you're in custody, but maybe that can help you when you're released. And then in cause number 2024 CR 1853, the court is finding you guilty. The court will sentence you to 4 years in the prison, give you credit for any time served. There's a $2,000 fine, time and money will run concurrent. This will run concurrent with 2024 CR 008966. taking consideration 2024 CR 1854, and there's to be restitution, if any, to Samuel Brazier. And I'll also request the therapeutic community. Again, the therapeutic community is there to help you if you have any type of mental health issues or medical issues. So if you serve 4 years, they won't keep you because you haven't completed the therapeutic community. I do not have jurisdiction to force them to let you be in the program or to order them to place you in the program, but I think it's something that you probably need, okay? All right, and each of the cause numbers, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal?
Yes, ma'am.
And did you understand it and sign it?
Yes, ma'am.
And each of the cause number, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
We can go off the record. How old are you?
26.
All right, you're 26. You still can turn your life around. When you were young, what did you want to be when you were thinking about what you could be in this world? Oh, what is it?
I wouldn't.
Okay, I hope it's not. Were you around when Julia Roberts had her movie out?
No.
All right, I'm just saying that because there were some people in my school, they're like, oh, I'm gonna be Julia Roberts. And I was like, that is a crazy idea. But here's the thing, what I'm telling you is you still have a chance. You're not in the twilight of your life. I'm in the twilight of my life. So you still have more of your life in front of you than behind you. So you're gonna have to make some changes. And this whole thing with inserting drugs and going to the jail with it, you could have died. And then the person who, this is how far addiction will take you, right? The person who got, had vomiting and everything, they actually took some of that drugs from you. That's what they're saying, that you uninserted it and gave them some and they got sick. So when you think about that, when you get clean and sober, you're just going to be like, who would do that, right? So when you go to prison, if I'm still here, when you get out of prison, if you need a place to stay, of course, you won't be staying with me, but if you need housing or you need help with drugs or whatever, you can come back here and I will pick up the phone and find a place for you, okay?
Okay.
And do not put any more tattoos on your face, okay? And don't get involved with anybody who wants you to put their name on your face. You understand? All right, good luck to you, okay?
Thank you, Judge.
You're welcome. Do you have a dismissal?
Yes, Judge. There we go.
All right, good luck to you.
Thank you.
All right, who are the two people in the box? We're done, right?
No, Judge. No.
Are we staying here till midnight?
No, we've got Hank Maldonado, Tony, and I need to approach you on that. We're gonna talk to my client real quick.
All right, I don't have the file on Hank Maldonado. All right, we're gonna take care of that. Yeah. Okay, so guys, we're gonna have to finish with the inmates because the deputies, they have to take them, transport them back themselves if we're not out of here by a certain time.
Judge, I think we're ready just to approach on Mr. Maldonado.
All right. What is happening with Maldonado?
Your Honor, I think we're close, but state's asking for 2 weeks so that we can reach out to 2 victims, 2 separate cases.
All right, Ms. Ferguson, can you give me a 2-week reset on Maldonado, please? All right, November 14th. All right, and who's the other person? All right, Mr. Maldonado, we'll bring you back on the 14th, okay? All right, Jonathan Morales, who is his attorney? All right, Mr. Morales, come down. Do not leave. Right here. Mr. Morales, your attorney, Mr. Cuellar, is no longer working as defense attorney. He has a new employment. So Mr. McLean is going to represent you. All right. And what we can do you want to call him back on the same day, the 14th, or do you want to call him back on a different?
Back on the 14th, we can do it soon. I can try to Zoom, let's do a Zoom here, okay? Yeah, and I'll get the information for you, and I'll usually stuff in place, okay?
All right, so we'll bring you back on the 14th. And do you have any objections with Mr. Cuellar being removed? All right, okay, thank you. All right, we'll be back on Monday, right? Okay. Trick-or-treating doesn't start till midnight. It's like, I went to a club.
Judge, are you just going to just make yourself feel good that you're not allowing me after we missed?
There's kids already knocking on doors already.
Right now.
Well, I will tell you, I thought trick-or-treating was like going to club. The last time I went to a club, they're like, Stephanie, what are you doing here at 8 p.m.?
When I went back in the day, I'm talking about today, Judge.
Trick-or-treating doesn't start till midnight.
If you start by 6, the candy mostly all gone.
Ah, see, you're gonna have candy for them. Oh, we have some candy back. You can take that.
Maybe excuse Judge?
Yes.
Thank you.
If I tell you what, if Tony has business cards, we can hand out business cards to the trick-or-treaters.